A third-grade girl got in trouble for wearing a pro-Second Amendment hat to her school's hat day a couple years back. The case was taken to court with the help of the Firearms Policy Coalition, and now a judge has ruled that pro-gun hats are not protected under the First Amendment. Hello everyone and welcome back to the channel. In February 2022, a third grader in Michigan, identified only as CS, wore a Come and Take It hat to her school's hat day. The hat also had an embroidered AR-15 on it, which apparently this school considered a weapon. Two different school officials called the child's father to discuss disciplinary measures and to tell him that she wasn't allowed to wear the hat, and that he would have to come to school with a different hat in order for her to participate in activities which would have gotten her a prize. So definitely some exclusion happening. Then they locked up the hat in a locker. The school said that it went against their weapons policy. The hat in question had a picture of an AR-type weapon on the front of it. Weapons of any kind are not appropriate for students to wear in a school setting, Principal Amy Leffel wrote in an email. The school policy says that anything printed on clothing must not be offensive in any way. The building principal and staff has the right to decide what is offensive, but some examples are words or slogans that advertise illegal substances, words or slogans that are racially or religiously offensive, violence themes, vulgar or sexual innuendo, etc. The lawsuit claimed that the hat does not fall into any of those categories, and I am inclined to agree, and that the school violated her First and 14th Amendment rights by not providing objective criteria on what is and isn't allowed. Because whether or not something could be offensive is purely subjective. Now, before I get to some of the ridiculous arguments made in the judge's ruling that feelings are above First Amendment rights, today's video is brought to you by Blackout Coffee Company. Blackout is a Florida-based roaster that keeps you awake, not woke, and always supports your Second Amendment rights. They support veterans, soldiers overseas, some of your favorite gun rights groups like GOA, and channels like mine. So to support them and support the channel, go to blackoutcoffee.com/libertydoll. The suit was filed in district court and named the superintendent, the principal, and the school's behavioral specialist as defendants. As for the specialist, his office is across the hall from the child's locker, and he was the one that noticed the hat when she waved hello that morning, and then he was the one that reported it to the principal. Not any of her teachers. And it was allegedly not an issue until around 11 in the morning, a few hours after school started. Now, the arguments made were the same ones that we've seen in similar cases, most notably pointing out that students don't lose their First Amendment rights just because they're young or in a school, as determined by the Supreme Court 50 years ago in the Tinker case. In that case, basically, it was determined that you can't punish a student for exercising unpopular political opinions. Valid argument. Now, here are the school's arguments. Well, said the principal, it has a weapon on it and the phrase, come and take it. I took that as threatening. The phrase itself seems like it's trying to incite someone to come and have an altercation to take the weapon. We're in an elementary school setting and it's a gun-free zone, and I didn't feel that any type of weapons are appropriate in the school setting or anything that suggests violence. Guns often suggest violence. She went on to say that she was concerned the picture of the gun would incite violence at school. They also contended that because Hat Day is a school-sponsored event, they have full control over the event and that the hat did not constitute protected speech. The school's second argument was that kids are impetuous, lovely thing to say about your charges, and officials were afraid that kids would read the hat literally and disrupt class by trying to take the hat, which kids might do in any scenario, but okay. We strive to teach kindness to our kids, and making a declarative statement, come and take it, is often, I interpret it as inciting an altercation or could incite an altercation, she said. And finally, the principal said some kids at school had transferred from another school where there had been a shooting, and so she felt that the hat would incite fear in those students and make them unable to take any tests that teachers were giving that day. We have students that attended Robert Kerr that had moved from Oxford, and I had several conversations with their parents, and those students were receiving counseling and social work support to deal with the trauma. And so, with all these school shootings we have, it's a picture of an automatic weapon. I think wearing the hat could disrupt the educational environment. So anything that is involved in that, from classwork, if they're taking a test that day, it could have impacted it if kids were uncomfortable. Officials went on, I think mainly it would be objectionable because it has a gun and we're trying to teach kids how to be peaceful. I had to deal with a lot of kids with anxiety last year over school shootings after Oxford, and I just think it would make students uncomfortable. According to the lawsuit, no students complained or said that they were uncomfortable, showed any fear, or had any issue with the hat. The issue was purely with the principal, school counselor, and superintendent who just so happened to be there, and the student's teacher. She was pulled out of class and singled out and told she hadn't done anything wrong, but that her choices were inappropriate. The school says that the kid was unbothered, but the parents say that she came home upset as she enjoys shooting sports, has been to Second Amendment rallies with her parents, and says that the hat helps her feel safe. Also, an embroidered silhouette of a gun is not a gun, it is not a weapon, it is not violence. Was it the best choice for avoiding conflict at school? Not necessarily, but that's not the point. Nonetheless, the judge and Obama appointee compared the hat not to the Tinker case, which established that students have free speech, but to a Supreme Court case in which someone gave a speech to their classmates that used sexual metaphors to refer to another student. That student was suspended, and the Supreme Court ruled that calling people graphic sexual names during a school speech did not fall under First Amendment protections, and that the school did have the right to suspend that student for disrupting the school day and being gross. The judge pointed to another case in which a principal took some articles out of the school paper because he was afraid that they revealed too much personal information about students who were struggling with teen pregnancy and family problems at home. The articles also allegedly contained sexually explicit content that he thought was inappropriate for younger students, and he was trying to protect students. The court sided with the principal in that case as well. But both of those are very different from wearing a hat. The judge did point to a 2022 case involving teens with Second Amendment t-shirts, but basically said it was useless because they didn't come to a definite decision as these students graduated before it was decided. Though in that case, the judges did argue that the school couldn't just speculate that something could cause disruption and couldn't censor speech over hurt feelings. Ultimately, the judge in this case said that because no one could prove that CS wore the hat as political speech, she was not protected, and that the Tinker case is really about schools not forcing kids to say things they don't believe, rather than allowing them to speak their minds or exercise other political speech. He also contended that the school was in the right based on the age of the students involved, claiming that it was reasonable to expect 8 and 9-year-olds to start fights over a gun hat. He also said that the trauma and anxiety of the other students trumps CS's right to wear a hat or show her political opinions. I feel like the Second Amendment is the only political opinion that applies to these days. He also said that because the request in the original suit filing was for the student to be able to wear the hat to school, and she is now moving up to a higher grade and will attend a different school next year, she might just try to exercise her speech later when she's older, which feels really patronizing and condescending. It remains to be seen if this decision will be appealed. While I think it's an important case and another example of some rights being granted above others, I don't know if it's necessarily a hill that I would die on. Though I don't at all agree with the school's decision or the judges, I'm not really surprised that that's how it played out. I'm curious to see what you guys think about this, so be sure to drop a comment and let me know. Alright folks, that is it for this video. Please like, share, and subscribe if you are new here. Ring that notification bell so you can be updated about all of my videos. And as always, thanks for tuning in and happy shooting.